and welcome to this ICE webinar on NEC adjudication lessons learnt. First, a little bit of housekeeping before we begin today. So you should all be able to see the housekeeping and helpful instructions on your screens. So one, make sure you click yes to the integrated voice pop-up when you entered no, and then log out and join out again, and you will ensure that you have sound. It will not connect your mic. You should hear sound, possibly music, for a little time after the host has entered. This ensures your speakers are working properly. Make sure that you use the question Q&A function. Look to the right of your screen and ensure that the Q&A window is expanded. If not, click the small arrow to the left so it is pointing down. Once the presentation starts, your questions to the speaker can begin, and this is encouraged. You do not have to wait until he finishes. Simply click in the window at the bottom and then click Ask, and ensure you choose all panelists as shown below and press Send. We will endeavour to answer all of your questions either by today or effectively, if not during the session. I think we'll collect those together and be able to answer those after the session has finished. So this is NEC Adjudication Lesson Learnt webinar, and my name is Barry Trebes. I'm a project director at Mott MacDonald, and I'm delighted to be effectively hosting this webinar today. Alongside me, I have Patrick Waterhouse, who is director with Bowdon Consulting. Patrick acts as an adjudicator, a fellow of the Institute of Chartered Arbitrators, I believe, as well, and also acts as a mediator dealing with disputes. So we've got a very well-qualified guy here to deal with the questions about adjudication. So the idea of today's session is that we're going to cover during the session what is adjudication and what are the benefits, how it is used in the UK and elsewhere in the world. We're going to look at the common causes of disputes that come to be adjudicated, and we're going to see if there's any lessons that we can learn for NEC from the adjudication process going forward. So what is adjudication? So I'm going to hand over now to Patrick, who's a specialist in this field, to give us an insight into adjudication and how that may benefit us in using NEC contracts. So over to you, Patrick.
Well, thanks, Barry, and good afternoon, everybody. Well, adjudication is a quick form of dispute resolution. Some people might say it's a quicker form of dispute resolution. It has been a feature of NEC contracts since their first publication in the early 1990s. It was not invented by NEC, and it has been used in a variety of other contractual situations as well. The process is referring a dispute between two or more parties to a contract to an independent person, for that person to then make a legally binding decision on the dispute in question. The starting point for adjudication, both within NEC contracts and elsewhere, is that the adjudicator's decision should be issued within 28 days of the adjudicator having the dispute referred to him or her. The period can be extended, certainly within the UK jurisdictions and certainly within NEC contracts. It can be extended to 42 days by agreement between the adjudicator and the referring party. That's what we call the party bringing the dispute. And it can be extended to any other period by agreement by the adjudicator and both parties.
Just thinking about that in terms of what is adjudication, is that some people maybe see adjudication as being a bit of a failure? Do you see that as being, or is it a good thing to adjudicate?
I think it's a good thing. It's difficult, we'll see this later in the presentation today, it's difficult to come across precise statistics for adjudication because it's all undertaken privately. But the anecdotal evidence is that most disputes that reach an adjudicator's decision do not go any further. The parties leave the dispute at that point. Whether they are content with that or not, we don't know, but it's only a very small proportion that then go on to subsequent proceedings elsewhere.
Yeah, and just one other point on that, Patrick, is it possible, you talk about it be temporarily binding, is it possible that the decisions can actually be binding between the parties if they want to?
The parties, if they expressly agree, can decide that an adjudicator's decision will be finally binding on them. And indeed, there was a case in the Technology and Construction Courts this year where that happened, where the parties had agreed that would be the final form of dispute resolution for their contract.
All right, good, thank you.
So it's temporarily binding, and the phrase that's often used is that the party that has been the subject of the adjudicator's decision should pay now and argue later. So where an adjudicator issues a decision saying that one party should pay another X pounds, they must do so even in the event they believe there is something wrong with the adjudicator's decision and that they intend to take that to further proceedings. The courts have shown themselves in the UK to be supportive of adjudicators' decisions. Occasionally, adjudicators' decisions are not enforced, usually for lack of jurisdiction or for the adjudicator's failure to follow the rules of natural justice. Now, in NEC, similar provisions across the entire suite. Just in case there are any brief differences today, I'm focusing on the engineering and construction contract. There are two options labelled W1 and W2. And as with all of the other options to do with secondary options, main options, and so on, this one should be identified in contract data part 1 in the opening sentence. Now, within the UK, there is specific legislation governing how construction contracts disputes should be resolved. You'll see in a subsequent slide that's the Housing Grants Construction and Regeneration Act in England and Wales and in Scotland, and the Construction Contracts Order in Northern Ireland. That places obligations on parties to what that Act calls a construction contract to do certain things. Option W1 in NEC documents does not comply with that legislation, primarily because it restricts the time period that parties have to refer a dispute to adjudication, whereas one of the fundamental parts of the construction contracts legislation is that parties should be free to refer a dispute to an adjudicator at any time.
Just out of interest, Patrick, what is the time? Is there you said about the time scale in W1. Is there a specific time scale?
There is a table in W1 that details the types of disputes that employer and contractor may have, and restricts the time period for bringing those disputes. It's consistent with all of the other provisions of NEC contracts, which are designed to deal with issues at the time they arise and not put them off for another day much later on. Option W1 is therefore not used very commonly in the UK. There are many areas of what we would normally call construction do not fit within the definition of construction contracts in the legislation. Primarily, to be safe, you see that option W2 is selected by most employers. The two options, W1 and W2, specify, firstly, how the adjudication should be conducted. Who starts the process? How do you start it? Who is the adjudicator? And they go into the detail of the exchange of documentation, the authority, the jurisdiction that the adjudicator has, when he or she must publish the decision, and both options go on to explain what happens next if one of the parties is not satisfied with the decision. I think it's safe to say that it's unique with NEC contracts that adjudication is required for all disputes prior to a party referring it to arbitration or litigation. And both options state that you cannot take your dispute somewhere else until the adjudicator has issued a decision on it first. Now, coming on to how you get an adjudicator, essentially there are two choices in this contract and in most others. There is a space in the contract data part 1 for an adjudicator to be identified. So it could say the adjudicator is this person. More typically, you tend to find that that space is left blank and the name of an adjudicator nominating body is identified in the contract data, which the parties would refer to in the event they could not jointly agree on the identity of an adjudicator.
Do you think there is any preference, Patrick, to whether that, you should name them in the contract or they get named later, or does it not make any difference? Or
I think my preference is they should not be named in the contract. There are two reasons for that. Firstly, at the outset, you're hopefully setting off not planning on having any disputes, but certainly you won't know what the dispute will be about. It could be a legal dispute about the interpretation of the contract. It could be a geotechnical matter to do with ground conditions. It could be to do with steel design. It could be to do with the finances of construction. So you're better off waiting to know what your dispute's about so you can find the right person. But secondly, and probably more importantly, is the adjudicator has to bring this process to a conclusion, potentially within 28 days of having it referred to him. If you refer a dispute to someone just as they're going on holiday for 3 weeks, they will be unable to act. So typically the parties go and try and either agree an appointment, or the referring party goes to an adjudicator nominating body, and at that stage you know what the dispute is and you know the timescales. Now, there are many benefits of adjudication, and we've summarised really 3 of them here. And the first is speed. You can typically get an adjudicator appointed within a couple of days through any of the adjudicator nominating bodies. Certainly the ICE here at Great George Street will do that. And then if you work on a 28 days adjudication timetable and a decision that requires the payment of money within 7 days of that decision, that means a party that is needing payment of something that's being withheld can potentially force that to happen in just over a month. It's certainly quicker than the timescales that we were certainly seeing before adjudication, when people effectively had to rely on the courts to do that.
Am I right in saying, Patrick, about it is contractually enforceable, isn't it? A decision of the adjudicator that has to be put into place.
It is, and you often tend to find enforcement proceedings in the event one of the parties has refused to comply with an adjudicator's decision. Yes. Typically by not paying an amount that has been required. Yes.
So that, obviously, in terms of the speed, that compares, having a very quick process to do that. I mean, I guess in NEC speak, it's about, if we take one of the principles about NEC about greater certainty of outcome, I guess that fits in the idea that there's something here that moves the project on, so people have got an understanding where the project's going to in terms of cost and time under the project.
They do, yes, and we want to avoid, and I think NEC is very good at avoiding, creating a large pile of problems in a filing tray somewhere to deal with at the end of this job when we've got time to do it. Yes. And that tends to fester. It tends to create problems for both employer and contractor in terms of their financial position with the project. One of them's worried, what's it going to cost me? The other one's worried, what am I going to earn for doing this?
Yeah. So I guess, again, one of the benefits is maybe it's a positive thing to, if you've exhausted all the routes of talking to each other and trying to resolve a dispute, that actually having somebody come in helps you to move forward in the project and try and maintain that greater certainty in outcome.
That's right, and despite the word dispute, you do sometimes get dispute resolution where both parties are almost keen for it to happen to resolve a matter and to move on from it.
Right.
That's not always the case, but sometimes it is.
Right. Okay, that's good. Thank you, Patrick.
The costs certainly have increased since adjudication was introduced to the UK industry in the late 90s. It's still, I'm told by those with experience of litigation, it is still a cheaper process than litigation. The parties to adjudication generally do not have the ability to have their costs repaid by the other party in the event they are successful. So it is a cost that the parties have to bear themselves, and as you can imagine, when larger sums of money are in dispute, then parties tend to spend more money on defending or pursuing a case for that money. And finally, confidentiality. When a case goes to court, we've all seen the comments in the press when documents subject to discovery highlight things that are embarrassing and occasionally amusing. And with adjudication, it's held entirely in private. Nobody else knows it's happening. Where things are exchanged that are potentially unhelpful in terms of the performance of one or both of the parties, it is not then digested by a public audience.
Yeah. So again, it's another positive feature of the NEC contracts to have adjudication there as part of one of the tools and processes to try and help the project move along and get a successful outcome and resolution of issues.
That's right, yes.
Good.
So I was asked, how much adjudication is there? Well, it is very difficult to quantify it accurately. The process is confidential. There are, I think, 12, 13, 14 adjudicator nominating bodies in the UK, of which the ICE is one. They usually publish anonymous data, and when I say anonymous, they don't tell you who the parties have been, but they will usually say we have had X adjudications referred to as this year. So I actually bumped into the person who runs the ICE panel earlier this morning, and we are close to 100 appointments of adjudicators at the ICE this year.
Yeah.
Which is higher than it's been for some time, I understand. Some of the other adjudicating nominating bodies publish their statistics, some don't. You can see in the small print at the bottom left of your screen that there's a joint survey undertaken by Glasgow, Caledonian University and Construction Dispute Resolution each year. And if you look at their statistics, their reports are online, you'll find them if you do a search. Suggests somewhere between 1,000 and 1,500 adjudications per annum in the UK across all forms of contract. I've not seen anything that separates that down into how many are NEC, JCT, FIDIC and so on. Now, in the UK, because of the success of adjudication and possibly because of the statutory right to adjudication, arbitration has very much been sidelined for domestic construction disputes, still very popular in cross-border projects, but the number of appointments I know the ICE has made for arbitrators in the UK in recent years has been very low by comparison. So it's certainly largely the accepted way of resolving disputes in construction. And for those of you who follow the judgments published by the Technology in Construction, you'll see there are still many disputes that reach the courts there. So adjudication elsewhere in the world, this isn't purely a UK invention. Adjudication can be agreed by parties to a contract, or it can be required by legislation. And being agreed by the parties in contract has expanded the use of adjudication. Certainly in the United Kingdom, there is an exemption from the Housing Grants Act for contracts signed pursuant to the Private Finance Initiative. The process of adjudication is very commonly written into contracts as a contractual procedure, not as one that's required by statute, because both government and the contractors it contracts with find it a helpful way of resolving disputes. Now, within the UK, the Housing Grants, Construction and Regeneration Act, and you'll be tested on this later, it was recently, back in 2011, amended by the Local Democracy, Economic Development and Construction Act of 2009, covers the jurisdictions of England and Wales and Scotland. There are some minor detailed differences in the way it is implemented in all three countries, and in Northern Ireland it's by virtue of the Construction Contracts Order. We don't have the time today to go into detail about the provisions of the Act and the Order, but they lay down minimum requirements for parties to construction contracts in respect of payment provisions in contracts and in terms of dispute resolution, which is primarily to do with adjudication. Several countries elsewhere in the world have followed the example of the UK. You can see two that we've got on the screen here at the moment. They're by no means the only two, they're just topical. The Republic of Ireland is in the throes at the moment of appointing, I think it's a ministerial panel of adjudicators for its construction contracts adjudication, and in Hong Kong the similar legislation is about to come into effect there, and we at the ICE are working with colleagues at the Hong Kong Institution of Engineers at setting up training and assessment for them to do similar roles to adjudicators here.
Yeah, can you start, there's obviously a massive variety there, Patrick, of perhaps variance in the way that adjudication is done, both here and the kind of UK and also internationally. So I guess the thing is that you do need to be careful, make sure you read what the adjudication procedures are, because it's very procedural, isn't it, in terms of notifications and the like.
It is, and that's where some of the challenges come in the courts to an adjudicator's decision. If something's been issued a day late, someone's not been offered a chance to comment on a document. And particularly when you look at contractual adjudication provisions, where the drafters of the contract may have elaborated further on what the minimum requirements of the legislation and added extra things in. As with all contractual provisions, the clue to getting it right is to read the contract, to understand what's required and to stick to it.
Good, thank you.
So what are the common causes of disputes? Well, it's nothing new, quite frankly. It's time and money usually in construction projects. Money usually being the end of the adjudicator's decision. What causes arguments over time and money tend to be around things like design, site access, poor quality construction workmanship materials by the contractor, interference in the works, and everything that costs money. In every construction project, there is usually a large number of organisations that are involved, not just employer and contractor. And the larger the project, the longer the supply chain and the number of subcontractors, suppliers and others involved. And every time something changes, it has the ability to change the time, the money, and I guess the third thing that's not mentioned there is quality. The three are all linked together, and if something changes in time, cost and quality, the other two parameters probably change as well. Parties not doing what they have agreed to do. It is a frequent tale that adjudicators read, is when they get, first of all, the referral notice, which is when the referring party says, here is my problem, here's my dispute. And you read the referral and you think, oh, this lot had a really hard time, haven't they? This is dreadful. And then 7 days later, you get the response and you say, I see what's been happening now. And it is very rarely you see that both parties have stuck to the terms of the contract and done what they said they're going to do. And we're going to come on later in today's presentation to look at some of the NEC specific issues about not doing what you've agreed to do and why that causes a problem. Yeah. Quality issues and defects do lead to disputes, both during the project and afterwards. And we work in an industry where design is a creative subject. It's highly subjective, and people don't always get what they thought they were going to get. And as with any commercial disputes, you will end up with parties, when there is a termination of the contract, arguing about who is responsible and what sum of money is due to which party at the end of it, and whether it was reasonable, whether it's correct of the party that started the termination proceedings.
So that list there, Patrick, and we've obviously got the most common ones. Out of those, is there any ranking or one that's kind of more common than others, or is it just an equal spread across them all, would you say?
I think the most common one is changes to the scope.
Yeah.
And we see that in facilities management contracts, in the TSC, as much as we see it in construction contracts, where parties are arguing, first of all, is it a change, or is this something that was always provided for by the contract? And even in the event they agree it is a change, there's often a disagreement about the consequences of that change, how much time, how much cost. And for those of you familiar with the compensation event provisions of the NEC contracts, and particularly the engineering and construction contract, a large part of assessing the cost of compensation events is a forecast of the defined cost not yet spent. And that is a subjective basis, which naturally, with parties who have financial interest, frequently leads to a difference in opinion.
Yeah. Do you ever get disputes that are taken on maybe on a point of principle or something like that, or is that? Do you ever get people who are embedded with?
Points of principles are wonderful things to have, but they can be very expensive hobbies to pursue at times. And typically, I think in the overwhelming majority of cases, parties are bringing a case because they believe it's correct. They've probably received advice from their advisors that it's correct, and that what they're seeking is perfectly reasonable.
Yeah.
I've certainly not come across one where somebody's been pursuing something entirely on principle with little likelihood of success.
I mean, I think what I take from this slide here really is, Patrick, I mean, there's a couple of things that jump out to me. One is to mention about the scopes, the good quality works information. Actually, you know, the parties that, you know, effectively NEC speak, act as stated, do the things that the contract asks you to do.
Yes. I think 3 words that come out of a lot of works information related disputes are cut and paste. And
yeah.
Where the works information has been drawn up from a previous similar project, and everybody does cut and paste. I do cut and paste. The sin in that situation is not getting it proofread properly before it becomes a contract document.
Yeah, good.
So, lessons for NEC from adjudication. Well, speaking to a few fellow adjudicators in drawing up this list, there were several things came out repeatedly, and that's what I've tried to bring out here. So NEC contracts from 1991, when the then New Engineering Contract consultative version was published, said we are here to act as a stimulus to good management. And it is throughout the contract, not just in terms of disputes, but where parties do not act as stated in a contract, there is usually a sanction to, we say, act as stimulus. I don't know what the opposite of a stimulus is, but they're often an anti-stimulus. And those sanctions do affect the party's case in adjudication. If you are going to an adjudicator seeking for him or her to enforce your contractual rights, you have to demonstrate that you've done what the contract requires of you. Now, clause 10.1 in all but one of the NEC contracts talks about the mutual trust and cooperation, which we haven't got up here, but because we think the more important sentence here is that the parties shall act as stated. And as you can see in brackets, we say that isn't optional. Most of the actions attributed to people or companies in the NEC contract are mandatory. There's very few uses of the words may. It usually says that project manager does this or the contractor does that. And where it says that somebody shall act as stated, that means that the contractor has to submit a programme for acceptance. That means that the project manager has to respond within a period for reply when a question is made, and so on. And the notification provisions in this contract run all the way through the contract. And it is important for the contract to act as a stimulus to good management, for the parties to stick to those. And I put here, don't be coerced into not acting as stated. So here's 2 regular statements I and other adjudicators have heard. A contractor saying, we can't afford a planner. This project isn't big enough to warrant one. We don't have anyone. Well, under section 3 of the core clauses, there are very clear obligations on the contractor to provide and maintain an accurate programme that all of the participants in the project, and I say participants, not just parties, can rely upon. And a very popular refrain from a lot of project managers is stop sending me early warnings. They are viewed in certain quarters as an opening shot in a claims battle, yet they are a vital part of the functionality of this contract. And in terms of both examples you see on the screen, providing an accurate programme, providing early warnings, are part of the value proposition the contractor is being paid to deliver. And it is wrong of the contractor to unilaterally say he's not going to plan the job properly. It's wrong of the project manager to say, I don't want you to tell me of things that might go wrong and cost us money. And when I say that, don't be coerced, a lot of participants in projects get quite almost depressed that when they are submitting documents to the other party, they're meeting a wall of silence, they're disappearing, they never hear anything else. Well, keep doing what the contract requires you to do. There's a better chance the project will finish successfully. You won't meet an adjudicator if you do that. But certainly, if you do end up in adjudication, your particular party will do much better if you can demonstrate to that adjudicator you've done everything that the contract requires.
I think what is one of the problems, Patrick, there that people see notifications and the issuing of notifications as being something that's not collaborative, not working together, when maybe the message should be it's about good management here, isn't it? And I'm not talking about that it's commercial or contractual. It's actually, this is about good project management, about giving early warnings and managing.
Well, the NEC, what I would term evangelists, will view the early warnings process as a collaborative tool. But you cannot deny it feeds through into disallowed cost in the target cost and cost reimbursement options,
yeah,
and it feeds through into a reduced assessment of compensation events for all compensation events if the contractor does not submit them.
Yes.
So to some extent, I think project managers are cautious when they receive early warnings, particularly when they receive a large volume of them, that is this collaboration or is this about to set off a large volume of incoming correspondence? I think they're absolutely vital, and I think because of the potential sanction against the contractor in the event he does not submit early warnings, his default position should be that if he wonders is this matter suitable for an early warning, the default response is yes.
And I think, and again, the key message I would take from this slide is again, there's no shall act as stated. So you do exactly what the contract is asking you to do, because I think no adjudicator is going to be critical of you if you've issued the right notifications at the right time under the contract. I mean, that's one way I think about it. If I had to stand in front of an adjudicator and say, right, what have you done? This is what we've done. We've given these notifications. Whatever the other party has done, if they've not responded, then we still, at least from our point of view, one party's point of view, they have actually done exactly what the contract asked them to do. And I think that's got to be the important aspect, hasn't it?
Well, sometimes you pick up a flavour of the relationships on site when you're doing adjudication. And a situation I encountered through adjudication a couple of years ago was a large construction employer had gone to great lengths to find a collaborative contractor through the pre-qualification and tendering process, thought they got the right company, and they spent a long time getting the contract documents right before they signed them. And on day one of the contract, somebody from the contractor came into the employer's project manager's office and put 450 early warning notices on her desk. And you tell that story to people, some say that's brilliant, that's just what that process is there for, to bring everything out into the open. Other people draw a different conclusion.
Yes.
And in that situation, I think the contractor had no obligation to do that until day one.
No.
But the employer in that situation had thought that the prolonged process of entering into contract would have reduced the possibility of that happening.
Yes.
So regardless of what the contract said, there was a certain suspicious feeling straight away there as to what was going on.
Yeah.
So some suggestions for when we put parties here, we deliberately picked a lowercase p. We don't just mean employer and contractor, but certainly project manager, supervisor, subcontractors, and anybody else working on NEC projects. Compensation events inevitably turn up in pretty much every adjudication you deal with. And it is no secret that the compensation event provisions can be lengthy, can be difficult to work with for new users, thinking particularly of Clause 63 and the assessment of compensation events. So it's important that everybody follows the provisions carefully. They monitor them and they adhere to the notifications and the periods for reply. Now, in our preparation for this webinar, we did discuss the use of online contract management systems. There are various ones out there. We don't want to appear favourites towards one or the other. But when you use those systems, they will track compensation events. They will tell you you've got 2 weeks left to do this or 3 days to do that. On larger projects with a large volume of correspondence, it becomes increasingly difficult to adhere to the contract if you're just relying on an Excel spreadsheet or an Access database.
Yeah. I mean, I guess from also a practical point of view as an adjudicator, does that actually, if you use an in the cloud system as such, does that help it make it easier for you to have the relevant information that you need for an adjudication? Does that actually Is there a positive there that it's actually more cost effective? That information has already been gathered?
Participants to adjudication still seem to like sending me a large number of boxes full of legal arch files. Increasingly, we are seeing, because of the high file size of adjudication provisions, we're now getting links to download services, but it tends to come digitally and on paper. We have the ability as adjudicators to issue directions to demand it on paper or demand it digitally. But I've not noticed, I've never been given access to a project database to look at what has happened and when. Be realistic in agreeing to extra time if the other party needs it, or indeed agreeing to do something quicker yourself if you've been asked. The provisions for compensation event quotations provide for the contractor to have 3 weeks to prepare a quotation. Now, if that quotation is for £10 million of additional design and build work, he hasn't got a hope of doing that in 3 weeks. If it is for something that's going to take one operative on site 3 hours to do, he should be able to knock that quotation out today. And parties that are requested to agree to different timescales need to remember that it may be them asking for the favour next time. And it is amazing how many times you see an adjudication where somebody has pointed the finger of blame at someone else for not adhering to these processes, how quickly the allegation is pushed back to them that neither have you.
Yes. I think that's an important point, isn't it? I think that certainly I've been on projects where they've unexpectedly, even after sorting out with a regulatory body, suddenly found they had a major change on their project. It's quite clear that actually this involved doing some quite major redesign and re-quoting for work, etc., that actually ending up agreeing a program to be able to do that. And actually took 3 months to actually get to the point of having a series of quotations to actually get to the change was so large that actually it's practical, isn't it, to try and do that to get a better, get a better outcome, a more precise decision on the quotations, etc.
The next point is entirely uncontractual, but do keep talking to one another. A lot of disputes, you get the feeling, could have been headed off had the parties spoken to one another more. In this contract, with clauses 13.1, 13.7, you are required to communicate in a form that can be read, copied and recorded. Notifications to be separate from other communications, but that still doesn't stop you ringing someone up, going and sitting down, having a cup of coffee with them and talking through things.
Yeah, I think that's a very important thing, isn't it, on lots of contracts where I guess that I'm just guessing here, maybe there's a bit of a thing with the adjudication where some of that's happened because the parties haven't been actively in dialogue and discussing with each other. In fact, I've certainly been on projects where we've been actively told not to go and talk to the other party, which seems a very strange thing to do, because it's that one of those things that actually you can cut away a lot of the issues by actually having some direct discussions. You might agree to disagree, but actually having that face-to-face discussion, dialogue, communication is really important, I guess. And maybe that's the thing, it's kind of out with the contractors a little bit, but it's about the working practice of how you're going to make that contract work. So having that regular dialogue and discussion, just generally, as well as in this situation where you've got potentially a dispute.
That's right. And even where you end up in dispute, if the parties have an understanding of what they do agree, it means they can limit what they're then referring to somebody else to decide for them. And
sometimes it can, I guess, be just a question that it is a misunderstanding of certain things, and actually they can resolve those things themselves through dialogue and discussion before having to go.
That's right, yeah, absolutely.
Good.
And we've named some clauses here. There are plenty more, but here are 4 examples. Where the contract encourages collaboration, and probably more correct to say it requires collaboration, but has some robust mechanisms in place for people that do not collaborate and do not do what the contract says they are to do. Of course, you see the first one there is the 25% retention from the contractor in the event he doesn't submit his first programme on time, or at all on occasions. A fairly significant disincentive against doing that. And there are other clauses in the contract that make similar sanctions, and they are designed to deter you from behaving that way. So some suggestions for parties continuing. Well, the adjudicator will enforce the agreement you have made. And I've put there, however poor a deal you struck in the first place. So if you have agreed a contract with the other party and it is not advantageous for you, if as employer you think you're overpaying or you're not getting the product you wanted, if as contractor you think you're doing this at a loss, it is not the adjudicator's job to prevent that from happening.
Yeah.
The adjudicator is there to make sure the agreement that you have made with the other party is enforced in accordance with that agreement and with the law.
I think that's interesting. I certainly had projects where I've had people on the project come to me and say, oh, the contractor's over recovering. And I said, well, no, actually, the contractor is recovering in accordance with the contract you set up with them. So you might not like the numbers that's now giving you, but that is actually that's how the contract's been set up. So it's not about over recovery. You're recovering in accordance with the way that you've set up your contract.
Yes.
The
contract gives both parties. It's not just about the contractor's recovery there. It gives both parties an entitlement for stated events. And with compensation events, I forget the clause number for the minute, but there is a statement that those provisions are the sole remedy for compensation events.
Yes.
So whether that leaves the contractor, feels he's under recovering, or the employer believes that he's overpaying, the contract it takes precedence there.
Yes, recovering the contract he agreed. Yeah, absolutely agree, Patrick.
And some of the oldest advice is claimed, I think colloquially, that it was a judge who once said this when he was asked, what are the 3 most important things you need to be successful in any claim situation? It was records, records, and records. Now, that is potentially easier in NEC contracts than elsewhere. Because if you follow the notifications regime, if you follow things like the period for reply, if both parties submit the documents to one another they should be doing, then a lot of the records, the dates when things happened, were notified or agreed, will be recorded anyway.
Yes.
And you're in any contractual claims situation, your legal rights are only as good as your ability to enforce them, and that often comes down to evidence. And remember that by the time a dispute reaches an adjudicator, the 2 parties may have been on that project 2, 3, 4 years. They know it inside out. This poor individual gets 28 days and a limited amount of documentation to become familiar with the dispute, with the project, and come to a decision. And it's only by virtue of primarily written evidence they're going to be able to do that.
Yeah, so I think the interesting thing is, and coming back to what you're saying there, Patrick, you act as stated. Actually, I guess you have to state and give the right notifications, etc., that the records become, like a natural part of the overall process in the NEC, isn't it? Because you're kind of gathering that information as you go along. Yeah. And of course, I think again, as you say, is you don't always know that there's going to be a dispute later on. So actually, having good records helps to when you come to examine those situations, helps you to make a decision, informed decision, by people having good records.
Yeah, it's certainly too late to generate those records when you get to the point where you realise you do need them.
Yes.
And there's a whole host of reasons why you need to keep good records on site, aside from dispute resolution.
Yes.
We all know about, certainly in the UK, the CDM regulations, about the potential for your project to be rebuilt, expanded in the future. All of these things point to the need to have good records, audit process and so on, not purely the fact that there might be a dispute one day.
Yeah. And I suppose that's one of the things people do say is, people who have the best records probably have the best chance, I guess, of getting a favourable decision, I would imagine.
Well, they've got a better chance of demonstrating to a complete stranger that what they say is correct.
Yes, yeah, okay. And I think, obviously, I think some of the other things I'd pick up from, what we've gone through, as Patrick, from the slides, is again, act as stated. This whole idea that we're going to talk to each other as well is good, and having good quality works information, setting out the scope of what you're going to do are all important aspects of this as well, aren't they?
They are, absolutely. And the works information is absolutely key to a successful NEC contract. Ditto in the TSC with the service information, as it is with the specification in more traditional forms of contract. If you cannot describe in the contract what you expect of your contractor, there's going to be a limited chance of you getting it.
Yes. That's very good. So I think that's Can we get to the end of the formal bit there? I think, Patrick, haven't we, in terms of the slides? We're about to come on to the questions. So as a bit of housekeeping, I think if you remember in terms of the questions to the speaker, you should find, if you simply click in the small window at the bottom, then ask and ensure you choose all panelists, you'll be able to send through your questions. So several of you already have been visually sending in the questions, so we'll start to have a look at those questions. So we'll just start off with one or two maybe to start with. So what's the first question? What if a contract for a project situated in the UK and subject to the laws of England and Wales includes W1 and not W2?
Well, reading between the lines and assuming that the person who asked that question was also saying it is a construction contract for the purposes of the Act, then the parties, if they are still collaborating, could agree to use W1.
Yeah.
But the fallback position under the Act is that something called the Scheme for Construction Contracts will apply instead. The Act sets out a number of minimum provisions for adjudication in construction contracts, and says that if any of those minimum provisions are missing from the contract, then this document called the Scheme for Construction Contracts will apply instead. The scheme is what's called a statutory instrument. It comes out of the Act, and there is a different scheme in each of the four countries within the UK.
Am I right in saying as well, Patrick, that maybe in some instances W1 would apply because the project actually falls out of the description of a construction project? There are exceptions, I think, it's demolition and various things that are.
If you go to the Housing Grants Act, there's half a page of exceptions, which it is rumoured from those who are more familiar with the machinations at Westminster than I am, that resulted from very effective lobbying by trade bodies representing those industries at the time. There's half a page of exemptions, and the danger for somebody picking W1 is on projects where maybe the vast majority of their work is not a construction contract, but some of it is. And then you would end up with only part of the works falling within the jurisdiction of W1 and part of it elsewhere. If you specify W2 within the UK, you are not going to have any problems with it enforceable.
So, okay, so the message there, be careful which W you choose, I guess.
Indeed, and further than not just be careful which one of the two you use, I have seen more than once where solicitors preparing contract documents have cut and pasted things themselves and have managed to include at least two different forms of adjudication procedures within the same contract, which then creates potentially the use of the scheme as the third option.
So beware of cut and paste as well, Patrick. Yes, absolutely. Good. Right, so we've got another question here. Is there a typical cost of adjudication?
There isn't, no. You can get, because you're paying your own costs, you're never going to get those back. There is a minimum dispute value, and that will differ by organisation as to what your appetite is for these things. And it can go up to millions of pounds that are in dispute. And clearly where a claim is being pursued or defended that is for a 7 or potentially 8-figure sum, parties are going to be willing to spend a proportionate amount of that on their defence or pursuit.
Just following on to that, is there how are the costs apportioned? Who pays the costs for adjudication?
The parties pay their own costs, which usually are the vast majority of the costs included. The adjudicator has the jurisdiction to allocate his costs as he sees fit. So he can say party X was largely unsuccessful here, so they can pay my fees, or he can say you can pay them 50-50 each. I've seen adjudicators who look at how much money was claimed and then how much money was awarded and award the fees proportionally in that regard. You get all versions in between.
So we've got another question here, which is, this may be difficult due to lack of data, but NEC has been said to be less adversarial and more cooperative than other standard forms. Would you agree? In your experience, do you think fewer disputes are brought under NEC projects than others?
It is a very good question. The contract will be less adversarial and more cooperative if both parties do what they've agreed to do under the contract. And that is that is far more difficult on occasions than just remaining courteous and polite to the opposite people you're dealing with. It is doing the tough things like the early warnings, the compensation event notifications. It is agreeing to collaborate and help the other party with something that's not your liability. If you follow what it says, it works very well. I've often thought that actually good people make for good projects.
Yeah.
And if you've got good people working in the companies that are delivering the project, then hopefully the form of contract wouldn't have much effect on that. In your experience, do you think fewer disputes are brought under NEC projects? I don't feel sufficiently well qualified to answer that question. I spend a significant proportion of my professional life working with NEC projects, and the rest of it working with private finance industry projects, and in my experience, the form of contract hasn't really dictated the volume of disputes.
No.
And this is where we struggle because of the confidentiality of the process.
I was guessing, under that you do have, you tend to sort of have, there'll always be, however well planned, whichever form of contract you'll have disputes that arise. I guess with the NEC philosophy, and I think you make the point about you've got good processes, but it's also about the people and that willingness to discuss and engage with each other. Maybe that's the thing that makes the difference. Maybe some of these things don't progress on into full-blown disputes because people are being more cooperative and collaborative in terms of having discussions about things. There's no hard data on it though, is there? Certainly that's my experience over 20 years of NEC that I've found that to be the case. I think there are things, there still are issues, but there's more of a willingness to actually sit down and try and go through those and sort those out, perhaps than maybe with other forms, perhaps.
You see, with longer term contracts, so NEC term service contracts, which you often see 4, 5, 6 year terms, PFI contracts, which can be 25 to 35 years long, it can only take the change of one member of staff on one party to turn a very confrontational contract into a more harmonious one, or the other way around.
Yes. Yeah, I think that's very true. I think it's about people, isn't it? A lot of it is about people. And so we've got a question: who bears the cost of appointing an adjudicator? So I think we might just join the adjudication process. And how does the value of compensation is derived in principle?
The adjudicator will derive the compensation, if that's the right word, in his decision from what is stated in the contract.
Yes. Yeah. So using the principles that are already in the contract in terms of assessing, I think it's one of the clauses in there says in W1 and W2, I think, isn't it? Actually, you set it in the same process as you would a quotation for a compensation. Yeah. If two parties in different continents are joined in NEC through contract, where should adjudication be based?
In adjudication, the adjudicator doesn't necessarily have to meet the parties or visit to the site unless he or she believes that is necessary. If there was to be the need to have a meeting to explore oral evidence, then usually you can find a mutually convenient location where the adjudicator and the parties and advisors can meet. And clearly, if it's something, let's say, to do with construction defects and a site visit is necessary, then it's obvious where you go.
Next question. So let's see what here. Building on from clause 10.1, in the spirit of mutual trust and cooperation, isn't this a subjective statement? And how can you pursue a claim for compensation against this, e.g. contractors still commercially aggressive? Can a client argue breach of clause 10.1? That's interesting. We had a little bit of discussion about this earlier, Patrick, I think, didn't we? Over a coffee before we started today's webinar, actually.
For those of you who have yet to do your homework, clause 10.1 requires the two parties and the project manager and the supervisor to act as stated in the contract, and also in a spirit of mutual trust and cooperation. And this is a statement that is frequently seized upon by people saying, as here, what does that really mean in practice? Now, we've been suggested here that some contractors can be commercially aggressive, as the person asking the question has put it, not our words. Can a client argue breach of 10.1? Well, where a contractor submits a quotation for a compensation event that the project manager believes is wrong, then the procedures are there in the contract to deal with that. which is to either say, I don't agree with your quotation, please try again, presumably with some advice as to what you do differently second time, or I, the project manager, am now going to make my own assessment. And that's how you deal with what this person asking the question is called commercially being aggressive. In terms of spirit of mutual trust and cooperation, there hasn't been, I don't think, any particular case law examining this clause in this contract, but in good faith obligations generally, the courts have stated several times that these good faith obligations will not override express provisions elsewhere in the contract that the parties have agreed. So if the parties have agreed that delay damages of X pounds a day are due, or that, for example, 25% of the price of work done to date can be withheld for a programme not being submitted, then 10.1 isn't going to help the party that's complaining about that.
No. So got a few more questions in here. So again, I just want to pick up that thing about contractors being aggressive. I think that obviously one of the things with this is that obviously the contract positively encourages both parties to communicate with each other. So in terms of early warnings, notification of compensation events, that should hopefully put you in a better informed position where you are. I guess maybe some people say, oh, a contractor's just kind of actually sending me so many bits of communications, isn't he being, he's not acting in a, but I think what I often find is that actually if you look at the root cause often is that actually when you look at the quality of the works information, that it kind of encourages communication, because there are gaps and misinformation and ambiguity and inconsistencies that, and of course a contractor will need to actually make those notifications. So
yeah, before a contractor can place a materials order, a subcontract order, potentially spending significant sums of money, if the works information is not clear as to what they should be providing, then it's important they get that clarification before they then go and commit to orders, subcontracts, contracts themselves with third parties.
Yeah. Good. So I've got a question here. Is it correct that if the contractor or client does not agree with the adjudication verdict, then it can go to arbitration or litigation where it becomes binding?
I think historically 50% of adjudication parties do not agree with the adjudication verdict. It can go to arbitration or litigation. In NEC contracts, there is something called the tribunal, identified in contract data part 1, where the parties have already agreed in contracts that the final stage of determination will be arbitration or litigation, and typically after an adjudicator's decision. If there is a party that doesn't like it, if it's the party that's been required to pay some money, often they just point blank refuse. So that will then force the other party into taking enforcement proceedings in the courts or through adjudication. And then it does become finally binding when, unless it is a matter of that persuades the judge that it can go any further in the courts process.
I mean, do you find that mediation is becoming quite popular now as well as a form? Was that still kind of in its infancy in terms of?
Mediation is still vastly underutilised in the construction industry.
Yeah.
And it is a voluntary process. It does have a very good chance of success, and parties are not committing themselves to anything by going into that process.
And I'm just going back actually to clause 10.1 about the spirit of mutual trust and cooperation. You mentioned about the fact that so I think in the English law, the thing about good faith isn't as strong as if you go to, I think, into Europe with their system of that actually good faith has a bit more stronger kind of meaning in Europe in terms of their. So I guess you need to be careful maybe in the legislation or the country that you're operating the contract out of, do you? Or?
There are some jurisdictions around the world where when you work in contract, you have to act in good faith. It's a standing legal obligation. It's not something you agree or don't agree under contract. Whereas in the UK jurisdictions, it is something you can agree in contract, but you're not going to be required to unless you do.
Yes. Yeah. So again, you need to be conscious of which jurisdiction you're in when you're where you're taking these things. That's good. So I think that's all the time we've got time to take questions. We've collected. So thank you very much for everybody for sending your questions in. We'll try and collect those together and give some responses on the IC webpage. So just to give you an update on things that are coming up. So in February, we've actually got NEC program, Achieving Excellence, Achieving Acceptance rather, which is going to be presented by Rob Gerard and Ben Walker. And we can see in there the key points in there, 5 functions of the accepted program, program preparation and revision, transitioning from an administrative chore to a valuable tool, top tips, consequences of not having a program in place. So that'll be a very useful webinar to attend. So that's on the 18th of February, between 1 and 2 o'clock again. Just a reminder that NEC, and you can see here in the bottom right-hand corner, the NEC contract accreditation courses that are now available. So we can see the ECC Project Manager, ECC Supervisor, and also the Term Service Contract Service Manager accreditation courses, all excellent courses that you can get accreditation to run NEC contracts. And also a reminder that the NEC Users Group, and we can see again the reference in the bottom right-hand corner to the user group, has a fantastic amount of information about, a lot of free information as well, about the contracts, etc., and about further events, training and newsletters that are available under the contracts. They're all very useful things to tap into. And finally, if you have any, if you require any further information about the NEC, here are the details and contact details to contact the NEC. We'll be more than happy to talk to you and help advise you about if you're thinking or using NEC contracts to provide help, support and guidance. So just leaves me today as today's host to say a very big thank you to Patrick for his insight into adjudication. I think some really excellent points to remember there. So I think keep talking, have good works information, do what the contract says. I think our key message that we'll take away from this. So thank you very much. I hope you enjoyed it, and remember to tune in on 18th of February for the next one. Thank you.